So here are some common misnomers about wills and trusts. All too often, I hear somebody say to me, "Oh, I wrote my plan years ago. I'm good, right?" Wrong. Plans, even just 10 years old, can be wildly out of step with current laws. Folks who wrote a plan in 2015 were worried about a federal estate tax floor of 5 million, but now it's up to 14 million and stands to increase next year. So if you have a plan that's old, it probably needs to be updated because we've had drastic changes to the IRS code. Second misnomer, I put my house in the trust. I'm good, right? I'm totally squared. No. In fact, I'm working on a case right now that involves a bank account that was not tied to the trust. And there was no pour over will, so there's no way for us to retroactively from beyond the grave put that bank account into the trust. So that bank account is exposed to the probate court. It's going to take a year and a half to have the bank account released to the right recipients that are named in the trust, but we don't have a vessel to get there apart from a court order in probate court. Third common misconception is that clients can meet with the attorney one time and it's done. Even a good tax filing might require multiple meetings with that tax preparer. And similarly, an estate plan is going to need multiple meetings with the attorney to have the documents appropriately tailored to the family. A one-time meeting is going to be very tricky with fill-in-the-blank documents. And I would argue it's not going to be a relationship where the attorney is properly educating the client. Here's the fourth, because I've got 5 misconceptions to talk about here. The fourth is that the client is scot-free and done once they sign the plan. I'm good, right? We executed. Wrong. The signing meeting is usually just the kickoff to funding the trust. Funding the trust is retitling high-value assets into the trust. Either real estate has a deed that gets altered usually by the law firm who files on behalf of the client, and also any bank accounts that do not have a pay on death designation like retirement and life insurance, brokerage accounts often do not. Or we need to say that it does pay into the trust so that we can fund a sub-trust for minors. And then the fifth misnomer about wills and trusts is that people don't need to revisit the plan after they've divorced. This is a huge exposure to probate court. When people divorce, if their real estate is still within a joint trust, that joint trust, surprisingly, is not automatically void. We need to look at the marriage settlement agreement or the court order that accompanied the divorce to figure out who is meant to own that house and put a deed together that says exactly that. It's called an interspousal transfer. But the bottom line is estate plans require some finesse, and it's not a one and done type of relationship. As always, if you are looking for a revision to your plan, or you realize it's time to put a plan together in the first place, call us. You'll speak with me or my associate attorney. We'll give you at least 30 minutes of our time for free. You don't have to fill out paperwork in advance, but we are here to talk to you within the scope of a free consultation. We'll give you a quote, we'll figure out when we can get things underway, or at minimum give you food for thought as you shop other law firms.